6 top suspects of the 2007-2008 post-election chaos to appear before the court, suspended Higher Education Minister William Ruto has thrown a spanner in the works. Ruto, through his lawyers Katwa Kigen and Professor Kindiki Kithure, filed an application at the ICC pre-trial chamber seeking to restrain the prosecutor from applying for any summons to appear or warrants of arrest with respect to Kenya's post-election violence.
It is very, very dangerous to politicize justice, where the justice and the legal system is used to play politics. And that is why we are saying we feel there are certain rights which the Honorable Ruto is entitled to under the Rome Statute.
In his application, Ruto believes that he would suffer irreparable harm should Ocampo decide to present a criminal case that includes his name before the ICC judges. He says in the application that having been adversely mentioned by the WACI and the Kenya National Commission on Human Rights reports that were relied on by the prosecutor to obtain authority from the ICC pre-trial chamber to investigate Kenya's post-election violence of 2007-2008, he has reasons to believe that the prosecutor may have formed an opinion that he could be a suspect.
Telling somebody to explain what they know about post-election violence does not give specific details of allegations. There is need for such a person to know what is it that they are alleged to have done, when, where, with whom, so that they can be able to exonerate themselves.
Ruto in the application questioned how Ocampo could have conducted his own investigations, considering that the agreement between the ICC and the Kenyan government granting the ICC investigators status, immunities and privileges and authorizing them to operate in Kenya was signed in September 2010. Yet from as far back as April 2010, the prosecutor had been writing to alleged suspects, including Ruto, requiring them to explain what they knew about the post-election violence of 2007-2008.
Inaonekana ya kwamba Bwana Ocampo ameshaamua kuna watu fulani angetaka kuwashtaki katika mahakama ya kimataifa ya The Hague.
Ruto also cites Article 54 of the Rome Statute that requires the prosecutor to equally investigate incriminating and exonerating evidence. He claims that Ocampo ignored concerns that some witnesses were induced, coached and bribed by Hassan Omar, a commissioner of the Kenya National Commission on Human Rights.
Instead, the prosecutor disowned those people. He said he doesn't know them and did nothing about it. And so we feel that is a violation of the law that requires that exonerating evidence be investigated.
In the application, Ruto is requesting the court to supervise the investigations and ensure that they are done in accordance with the law. Ruto is also seeking the court to compel the prosecutor to investigate rather than dismiss evidence exonerating him, especially claims that certain witnesses were induced, coached and compromised to implicate him. Lastly, he is requesting the court to restrain Ocampo from applying for any summons to appear or issue warrants of arrest with respect to Kenya's post-election violence matter before the application is heard and determined. Ocampo is expected to appear before the ICC pre-trial judges on Wednesday next week to apply for summons to appear for the 6 top suspects of the 2007-2008 skirmishes. Francis Gashuri, Citizen Live at 9.